Let's look at different informed consent laws first. States are not consistent on the topic of how much information should be disclosed for an adequate informed consent. Both legal and moral standards differ among the 50 states. Some states do not mandate by law a written informed consent form. Verbal is enough. Informed consent is both an ethical obligation and a legal requirement spelled out in state statutes and case law in all 50 states. But in what way? Patient autonomy is the principal ethical consideration that forms the main element of informed consent. Significant criteria has been proposed through state boards and state laws. Let's look at that criteria. Informal disclosure. Disclose elements needed for the client to make an informed consent. So my thought about this is, how can they make, a lot of times people will read the informed consent or they won't read the informed consent. How many times have you went to the doctor's office and just signed the papers and not read it all? Maybe you don't do that now because you're in practice, but many people do that. How many clients have you had that you're not sure if they read it? So for me, what I've done is I've developed a checklist for my informed consent. I have a checklist of the main points. I'll have them read it, sign it, and many times you don't know if they did. So I review the checklist and I document in my documentation in their file that I reviewed the checklist with them, and they were cognitively able to understand what was shared and to give me consent. They understood. I want them to understand, because is it really an informed consent if they have not been informed, if they didn't read it and just signed it? I don't think it is. I think that would be hard to argue in court. My past is that I worked as chief of probation and a probation officer for many years. I'm retired with that, but I saw what happened in court, and something like this could go astray. Because how would you fight that? Were they informed? Yes, they were given an informed consent and they signed it. But were they informed? Did they really understand? Comprehension. Ensure the understanding of what's been disclosed. Competence. Assess whether they're even able to make the decision to participate. And then voluntariness. Promote the autonomy of the client to make the decision about whether to participate in treatment. So these are the four main things that are important when you're considering informed consent. Are you disclosing the elements? Are they really informed? Do they understand? Are they competent enough to understand and decide to participate? And are they volunteering, or are they being coerced? Then we have to look at duty to warn and protect. The term duty to warn refers specifically to a duty to warn an identified victim, whereas the term duty to protect is broader and allows for alternative means of protection from violence, such as notifying the police or initiating hospitalization when they need to be hospitalized to protect themselves. Duty to warn could be warranted when three conditions are present: a special relationship, a reasonable prediction of harmful conduct, and a foreseeable victim. Duty to warn laws are, the duty to warn is necessary in circumstances indicating that a party will be held liable for injuries caused by another, where the party had the opportunity to warn the other of a danger and failed to do so. A provider's duty to warn is based on what the courts view as a special relationship established between the treating clinician and the patient who needs mental health treatment. However, duty to warn is not required in all states. In fact, some states believe it's dangerous to warn the victim. So one example that I have, and I'm sure you have many, but I'll just give you this one. A gentleman called me. I was teaching anger management, and so he called me and he said, "I'm so mad at my girlfriend. If she comes home tonight, I'm going to punch her." He said, "I can feel it." I said, "What do you mean you can feel it?" He said, my fists are clenched and I'm ready to knock her out. I said, "Okay, well, I'm going to call her and I'm going to tell her not to come home tonight, to go stay at her mother's house. So what can you do right now?" He said, "That's why I'm calling you." And I said, "All right. So can you go mow your lawn right now?" He said, "It's already mowed." I said, well, what about your neighbor? What's he doing? Well, he's putting up his roof. I said, how about if you go help him put up his roof? I'm going to call your girlfriend, and then I'm going to call you back and see how you're doing in a couple hours. And he called me 3 hours later, and he said, well, I feel better now. I said, what does that mean? He said, that means I don't feel like punching her anymore. And she's not coming home anyway. So I'm good. I said, well, what did you get from all this? He said that I physically felt it. I didn't want to do it. That's why I called you. And I needed to release all that from my physical self. And by doing something physical, it helped me get rid of it so I could be in a better place. I'm like, well, that's great. That's great. And he didn't hurt her. She came home the next day and they worked it out. But he was cognitive enough to realize that he needed help. I did warn her, though. I did warn her. I felt like that was the best thing to do. But in some situations, it may not be the best thing to do. And in some states, you're not even required to because they feel it's too dangerous. State differences. Okay, there's different types of duty to warn in each state. There's different threats require or permit a provider to discharge duty to warn. And there's different actions that are required to discharge the duty to warn. So those three things are what you need to look into if you're especially seeing somebody that's a survivor of domestic violence, or if you're seeing somebody for domestic violence. That is my specialty. I see anger management and domestic violence clients. So that's why this is, I know that this is important, and I've included it in today's presentation. So if you're seeing anybody with that, you might want to consider looking those up and documenting that you look them up and that you know what the laws say in the state where they are, so you know what to do or what not to do. So there's state differences for duty to warn are how imminent and certain must the threat be for you to activate duty to warn? Must the potential victim be identifiable? How is the duty discharged? How do you do it? What are you supposed to do legally and ethically? Are required methods of warning or protecting specified in law, such as hospitalizing the patient, warning the potential victim, or notifying the police? I'm talking about suicide or somebody that's wanting to harm themselves or others. To which types of mental health and other professionals does the duty apply? And is immunity provided for good faith efforts to discharge the duty? Is the duty established by statute or case law? Here are the states with mandated duty to warn, and one should have to guess, and things change all the time. So this presentation today is from research I've just done this month, but it could change tomorrow. So you always have to check. Arizona, California, Colorado, Delaware, Idaho, Illinois, Indiana, Kentucky, Louisiana, Maryland, Massachusetts. I'm reading it because most times people don't go back and read. Michigan, Minnesota, Montana, Nebraska, New Hampshire, New Jersey, Ohio, Tennessee, Utah, Virginia, and Washington all have states with mandated duty to warn. So it's not a choice. That means you need to warn. States with permissive duty to warn: Alaska, Arkansas, District of Columbia, Florida, Hawaii, Iowa, Mississippi, Missouri. I know we have people from some of these states. New Mexico, New York, Oklahoma, Oregon, Rhode Island, South Carolina, South Dakota, Texas, Virgin Islands, West Virginia, and Wyoming. In some states, such as Texas, the permission to warn is limited to notifying medical or law enforcement personnel, not the threatened person or persons. It gives you an example of how it can be different. States with no set statutes for duty to warn, they don't provide any statutes addressing the duty to warn, but some of them have implemented the duty through court decisions. Connecticut, Pennsylvania, Vermont, and Wisconsin do not have statutory provisions, but they've established a duty to warn through court decisions. States that are silent as to the provider's duty to warn are Georgia, Kansas, Maine, and I know some of you are from Maine, Nevada, North Dakota, and Puerto Rico. So hopefully that helps a little bit in which one of you need to look things up and get it documented. States with limited duty to warn, a small number of states have statutory language or court decisions that may be interpreted as limiting the duty to warn. These include Alabama, Guam, and North Carolina. And there, you can look that up. This is one of the cases that made some of this change. Some state differences, types of threats requiring duty to warn. Some states require or permit a disclosure of confidential information to prevent a general threat to the public at large. Wisconsin, Delaware, Washington, and Nebraska. Other states require or permit disclosure based only on a threat to harm a specific individual or group of individuals. That's Arizona, Colorado, Louisiana, Michigan, Missouri, Vermont, and New Jersey. So different types of threats. Acceptable modes of reporting. Many states don't designate the acceptable modes of intervention. Example, in California, the duty to discharge happens when a provider makes reasonable efforts to communicate the threat to the victim and to law enforcement. Now, when I worked in California, I had to make both of those things happen. Tell the victim and let law enforcement know both. In Delaware, the provider may notify law enforcement and the victim to arrange for the hospitalization of the patient as an acceptable means of discharging the duty to warn. State laws and differences for mandated reporter. That's the easy thing to do. Most states have an online training you can take for a mandated reporter, which is usually free through the Department of Children and Family Services or DCS, however it's stated in that state. And they usually offer it for free, usually takes about an hour, and you even get a certificate and possibly CEUs in some places. So if you're going to see a lot of people in a certain state, that'd be a good training to take, and then you can document that you took it. Mandatory reporters are required to report the facts and the circumstances that led them to suspect that a child has been abused or neglected. They don't have the burden of proving that abuse or neglect has occurred. Approximately 48 states and the District of Columbia, the Commonwealth of Puerto Rico, and the United States territories of American Samoa, Guam, and Northern Mariana Islands and the Virgin Islands designate professions that are mandated reporters. And that's where I got this information. You can look that up too. And it says the mandated reporting laws by state on this resource. Some differences when what the penalty is for not reporting. It can be different in each state. And when to report is different. California, for instance, as soon as possible with a written report submitted within 2 days. Idaho says make a report within 1 day. Massachusetts, and I know there's some of you from Massachusetts out there, make an oral report immediately and a written report in 2 days. So there's differences in each state. Where to report can be different. For instance, Massachusetts reports to Department of Children and Family, and Mississippi reports to Health and Human Services. Important to know, where do I report? So what the penalty is, when to report, and where to report would be important to know when you're seeing somebody in another state. There are some state differences for state licensure requirements. Requirements for in-person visits, including an initial in-person visit to establish a provider-patient relationship and ongoing in-person visit requirements. That is not always a requirement in many states now, where it used to be. Online prescription of medications, including controlled substances and non-controlled substances. In some states, you can provide that, but in other states, you cannot yet. Some have become more lenient about that. And then some states have temporary practice laws to support existing provider-patient relationships, and they minimize the gaps in care. These laws allow for a provider to practice for a limited time, usually less than 30 days, in another state if their patient is temporarily visiting that state for business, a family visit, or for other reasons.